So, good morning, everyone. My name is Ainhoa Veiga. I'm a competition lawyer practicing here in Madrid. And let me start, you might not care, but I am a user of the local municipal bicycle sharing service here in Madrid. And believe me, it's so much a challenge that a hardcore cartel might be more efficient to make of myself a more sustainable human being, considering that my willingness to pay is limited, including the willingness to pay taxes to procure sustainable services. So thank you to the International Center for Competition Economics, and I'm very honored to be here today moderating this panel on sustainability and competition. Allow me to introduce my distinguished panelists. I'm starting with Maurits Dolmans, senior partner of Cleary Gottlieb, still Hamilton, in London and Brussels, right? Second, Julian Nowag, senior scholar of the International Center for Law and Economics, this center. Then Julian Nowag from Lund University. And finally, Cento Veljanovski, founder, Julian Nowag. Okay. And Cento Veljanovski, founder and managing partner of Case Associates. We are trying also, like the previous panel, to get some discussion, dynamic discussion. And I hope this allow me just a brief introduction to the questions I'm bringing on to the table. After this panel, I hope that we will show the merits or the relative merits of competition and cooperation in this context of urgent, very urgent sustainability goals. Just less than 2 weeks ago, you might have seen the international panel of experts on climate change, update of the situation. You might think, or you might agree or not, but it is clear that it is a sense of urgency where competition law, competition enforcement, competition policy has been called upon. And particularly in Europe, you all know, and Maria Pilar Canedo already said how they are seriously considering integrating sustainability considerations into competition enforcement, competition advocacy. However, there is room to think on whether antitrust competition has, or there is room to consider whether it is actually necessary to adjust the current tools, analytical frameworks, including economic models to meet or promote sustainability goals. And so my first question to the panel, and in particular to Cento, is whether there is a sustainability gap in antitrust and competition policy and enforcement.
And I have to, and for the following reasons. First of all, let's just be clear. The term is competition law or antitrust law. It is not to promote competition, but to prevent market abuses. So it's not a proactive area of law. It's a somewhat ex post reactive area of law to prevent attacks on competition and to provide a remedial system for that. So I was a bit amused by the relativism of the previous discussion that, you know, competition law is just a political artifact and then you can pour anything into it. And I was actually more surprised because I'm an economist, but I believe in the rule of law that everything was up for almost a cost-benefit assessment. You know, if you want greater income equality or sustainability, we just trade off a bit of certainty and a bit of efficiency and a bit of whatever competition is supposed to promote. I was also a bit surprised that the statement that promoting competition or competition law is about efficiency. I didn't realize that Oliver Williamson had such an impact, at least on US antitrust, because it's had almost zero impact in Europe. We're not concerned about efficiency, we're concerned about promoting competition and not promoting, preventing market abuses. So that's the first point I make. The second point is this area of law shouldn't pursue a whole range of other goals. It actually diminishes the law in the sense that it prevents effective enforcement. If the enforcement official and the firms being investigated are always saying, well, there's competition, but there's a trade-off here. We can bring a sustainability or a gender equality or a biodiversity or a privacy assessment defense against anti-competitive behavior, then not only is the enforcement agency going to be confused and making trade-offs and making different trade-offs, but those who are subject to the law will never really know what the law is. They will always be second-guessing the regulator and trying it on in a fairly aggressive manner. So the second reason why I don't think sustainability has a role in antitrust is, what is sustainability? The discussion has been mainly focused on the environmental interpretation of sustainability. But if you look at Julian Nowag's paper for the OECD, which gives the definition of sustainability from the UN, it's everything. Fair trade, good working conditions, happiness, for universal public health, gender equality, women's rights, full employment, the end of poverty and hunger. How is a competition authority going to trade off these things, even if it's got a legitimate role in this area? And the final, the final of the broader question, I'll come to the gap very quickly, is the limitations of antitrust. I think this was touched on in the first session, is that because we're antitrust practitioners here of various kinds, we think antitrust is the be-all and end-all of the law, and that every area of law should embody every other area of law. We have environmental law, we have tax law, we have monetary policy. There's an English expression, horses for courses. You pick the area of law that is most relevant to the area, and you have an enforcement agency that can effectively enforce it. To make each area of law cover all social ills and environmental problems is basically a ridiculous concept. And we have also, even if we accepted that there was a role for sustainability, what is the contribution of antitrust to this? That comes to, is there a gap? I've read a lot of the literature on sustainability written by lawyers mainly, and it's, I think, quite emotive and often exaggerated in terms of what contribution antitrust can make. Antitrust can only make a marginal contribution, especially when you realize the context in which these lawyers are arguing. First of all, cooperation is not illegal between competitors, at least in European law. It's only cooperation that leads to price fixing or horizontal agreements that violate the law. And there are exemptions to cooperation between competitors on standards, on R&D. So the law is cognizant of the fact that not all cooperation, even amongst competitors, is anti-competitive. So what we are really debating about is a very narrow subset of agreements which seem to fall foul of the law, which have anti-competitive effects. And the argument being made by the sustainability lobby, if I can put it that way, is that we should have a trade-off between market power and horizontal agreements that lead to anti-competitive consequences and sustainability, that there should be exemptions. And I go back to my earlier point about the risk that exemptions will lead to ineffective enforcement. So we're really, in my view, arguing about that, arguing about those cooperative agreements that don't have exemptions at the moment that give rise to, say, significant market power or anti-competitive consequences. Now, in my understanding of European, at least the practice of European Commission, and I imagine that this is the case for a lot of competition authorities, they prioritize their enforcement. They don't go after every lawbreaker. They say, we have a priority, we have a limited budget, and we have to use that budget effectively to get success, whatever that success means by the agency. And what it means for the European Commission in relation to Article 101 is to go for hardcore cartels. And I think there's been research done by one academic showing that the Commission effectively non-enforces a lot of cooperative agreements, or that might be anti-competitive, gets undertakings from it, but it prosecutes those hardcore cartels as the priority. And so a lot of this hiatus about, the formal law blocking cooperative agreements that might lead to some public interest benefits is probably, well, in my view, exaggerated, and I think empirically exaggerated for that. Now, there's no evidence really that the law is blocking these sustainability agreements. And I draw as somewhat of evidence, although I'm not going to say that I'm taking the Commission at face value. They had a consultation on the horizontal guidelines. And one of the major issues raised in the consultation, there was a lot of submissions, was on sustainability. They said, it should take into account sustainability. And I quote the Commission in writing about it, said, the stakeholders appear to have difficulty providing real-life examples of sustainability initiatives that are hampered by potential risk of the application of antitrust rules. So there was limited evidence that that is the case. I'll just briefly touch on the argument that cooperation will lead to more sustainability than non-cooperation or competition that doesn't lead to anti-market power issues. There's a debate going about amongst Dutchmen about this issue of whether sustainability promoted by cooperation or competition. There's a fair bit of evidence that industries that are more competitive engage in more sustainable efforts. But I'll stop there. I've got a lot more to say, but I'll stop there to give other people a chance to either react or agree with me.
Yeah, so where does it come from, the idea that competition stands in the way of sustainability goals? What do you think? Other panelists want to have any considerations, on what Cento has said, that there is no evidence, Cento said, that competition would stand in the way of reaching sustainability goals. So that is this the sense of urgency on sustainability goals that makes this a matter of priority and put competition policy and enforcement to the service of sustainability goals?
Organization of the panel. Do you want us to first do our initial
comments, first,
then the debate?
Yes, to have the debate on what Cento just said. Yes.
This is a conversation. Because I thought we had okay. That's fine. So my initial reaction, you're right to point to the IPCC report, the synthesis report that came out, which explains that global warming is a reality and it's caused by humanity, and it creates extreme weather events and could lead to tipping and rising sea levels and so on. That we can still solve it. And how do we solve it? To me, that should be the principle. How do you solve a collective action problem? Because the root of this whole climate change is a market failure or a collective action problem. And now I'm not an economist, but I'm quoting Sir Nicholas Stern, or I think he's Lord Stern now, who says that the climate crisis is the greatest market failure that the world has ever seen. And when you think about it, it's even from a common sense perspective, it's kind of understandable, because why should I spend money buying an electric car when my neighbor drives a gas guzzling big car? Why should I not fly when my neighbor constantly flies for weekend jaunts and so on? Why should I? So there's and my neighbor may actually think the same, but since we are not coordinated, no solution is found. So you have a situation where everybody would be better off if there were coordination, but nobody can or wants to coordinate because there is no framework for doing so. Now, many economists would say regulation is the answer. Pigou would say that taxation is the answer. And there is also Ronald Coase. And Ronald Coase says, if I understand correctly, in his theorem, you basically, it depends on two things. You need to allocate clearly who has a property right in the climate or in private enterprise. And you have to allocate the responsibility, who pays whom for either cleaning up or for not engaging in certain activities. And this can be done through negotiations, provided the transaction costs are not too high. So that's where antitrust law comes in. It's not that antitrust law is being asked to solve the climate crisis. The climate crisis, I think, should be solved through coordination. And regulation is one way of coordination. Taxation is another one. Government policy to drive innovation. Maria Mazzucato saying this is how we got to the moon, by private-public cooperation in order to invent new technologies. Maybe we should do the same with climate change. But private sector cooperation is also a way to coordinate. And so that's where antitrust law comes in. It should not stand in the way. And Cento says there are no actual examples. Well, I've lived this for the last 5 years. I have quite a lot of clients knocking on my door, talking about examples, and then saying, we're not going to do it because it's too risky. I'll give you one example, and then and I have my little decision tree that we should at some stage go through. But I'll give you one example, the so-called race to zero agreements, right? In COP26, there was an initiative by the Glasgow Alliance for Net Zero, a bunch of banks and insurance companies and asset managers and so forth, to say, okay, we have a responsibility to help coordinate the solution to the climate crisis. How are we going to do this? Well, they said we are not going to finance or insure unabated coal power plants and new coal projects. What's ongoing can continue, but if somebody knocks on our door and says, I want to start a new coal mine or an unabated coal power plant, so in other words, where the emissions aren't captured, then we're not going to finance that. And of course, that's a prime example of a collective action problem, because in a normal situation, when I insure, so imagine Cento and I are both insurance companies, and we are insuring a coal power plant. I will look at the physical risk for that coal power plant. Is it in an area where it can burn, where it can be blown away, where it can be drowned? And is it in geopolitical situation that is unstable? And I will set my premium by reference to that physical risk. What I do not take into account is the externality that this coal power plant emits greenhouse gases, which impose costs on other insurers like Cento. Cento's coal power plant, which he is insuring, has a physical risk, which is in part covered by my activity. His coal power plant, which he is insuring, creates an issue for my coal power plant, a physical risk. So those externalities, these costs to society, which are not included in the premium, are a problem for everybody. And the idea is, let's coordinate not to insure these things in order to force these power plants to use proper carbon capture and utilization or storage technologies, which increasingly are available, to give an incentive to invest in that, so that everybody gains, including Cento and I, whose premium can go down if emissions are reduced. So that's a prime example of a collective action problem that can be solved through coordination. And the GFAN's proposals were to do that. And of course, what happened was that about a year later, advice came under antitrust law saying, you can't do this. And therefore, the agreement was abandoned. To the great regret of a number of banks and finance institutions, because they wanted to do this, because they think it's part of their responsibility and their fiduciary duties to their own customers and shareholders. And so that is one example, and I think a very important example of an antitrust, of a corporation which was sunk as a result of antitrust law. And I can go on, but and eventually we'll need to go to because there's a lot more to be said. But
yeah, Julian Maurits wanted to say something.
Yeah, so I think it's interesting that the focus is immediately shifted towards climate change, but I'll take it as it is, and make the following observation, that if reducing emissions from coal-fired plants in Europe and the US were to have occurred as a result of coordination by banks on limiting access to capital, I think there's a legitimate question as to what would have happened. And one possible outcome would have been a shift in industrial activity towards those jurisdictions where no such restrictions are imposed. So, for example, India and China, which are still building coal-fired power stations by the dozen. So I think one question would be then, okay, so you've imposed this restriction. Have you actually had an effect on emissions? A related question, which I think is perhaps more important, is what happens in the longer term? Because climate change is a long-term process and emissions are going to carry on for some time. What we've seen over the course of the past century is the rate of emissions per unit of economic activities. So the volume of carbon dioxide per dollar of GDP or euro of GDP has declined pretty much uniformly, linearly, for about a century. Why has it declined in that way? Innovation. Innovations in various ways. Innovations in terms of the efficiency of use of energy, innovations in the efficiency of production of energy. One would hope that that innovation continues along that linear trajectory. It may or may not. I think the question, though, is what is going to motivate that? Is it an agreement among banks to restrict capital to coal-fired power stations, or is it the removal of barriers to the new technologies that are lower in their emissions? For example, third and fourth generation nuclear, which at the moment is highly constrained by all sorts of regulatory restrictions. So I think if you're going to look at the problem of climate change in the round, look at it in the round and don't narrowly focus on one particular possible direction that technology could go, or that you could try and restrict certain technologies. And that suggests that perhaps the antitrust action in this case wasn't such a bad thing, in the sense that it was saying, well, you know, this might or might not have an effect on global emissions, but what it will definitely do is drive up prices in those jurisdictions where it's applied.
Gladly answer later.
Yes, so I think there's like already so much said now. I don't know where to start. I'll try to focus a bit on a couple of points. 1, 2, 3, and then a question. So 3 points, and I think they are relating back to Cento. So first, I think it makes a lot of sense to use antitrust for what is design antitrust problems. So that would then mean, on the other hand, that we use sustainability law to address sustainability. But there are enough lawyers in here that will be able to tell me that there is nothing like sustainability law. Because sustainability law does not exist because it's a cross-cutting issue. So what we are facing here is essentially a question of if there is a question about sustainability in the context of competition, what do we do? And that's where competition law comes in. And how we do that, that's a completely different question. And should we do that, I think, was one of the questions raised, and it's also in the title of this debate. And I think that's a lovely question. We can all have our more views on that. They are hopefully informed by empirics and other things. But I think for lawyers, more views is one thing, but normative questions, they are designed and decided by the law. So we have to look into what the law tells us about these questions. And there are different laws across the world. They do different things. For example, talking about climate change, the Austrians have just changed their law and said climate benefits, they are benefits that benefit consumers by default. One of the arguments that we often hear is it should be the legislator that should decide these things. Maybe then we should all be now happy that the legislator has decided it. But I have not seen many competition lawyers that have been massively clapping at this change in the law, even though the legislator has now finally spoken. That brings me to the third point, which is the trade-off. And I think trade-offs, that's inherent in competition law. The question is, how do you do them? And how do you do them in a sustainability context? And I think there are different areas, and we can talk about the hard cases, but the easy cases, I think, are innovation cases. And that's, I think, where we all agree. Sustainability, innovation is something that you'll have to take into account when you're doing any kind of antitrust analysis. So you're trying to innovate in a sustainable direction. And that's something that we can use our tools for. That leads me to the question of gap, and then I come to the 2 points of my colleagues here. So I think the gap, yes, there's a gap. The question is how big it is. For some people, it's bigger. From some people, it's smaller. In some jurisdictions, it's smaller. I think the gap has also become smaller because we're having this debate. And I sometimes get reminded of when I started to work in this area, 2010, when I told people what my PhD was about, they said, oh, so you're studying how environmental protection laws affect competition? I said, no, I do environmental protection in competition. Hey, what does that mean? So it was a very kind of one or the other view. It was also the time where, I think it's like a different time where Tesla was just putting the first electrical engines into, I think, Lotus, was it at that time? It was the time where we didn't have the Paris Agreement, nor did we have the SDG, the Sustainability Development Goals. So a different time. So I think things change, and it's good that we're having this discussion. And I think while having this discussion, certain things that are perceived as gaps might appear or disappear when we are talking about them. And that brings me, I think, to the other question. Why do we so often hear about climate change? It's one of the biggest issues. And because if you think about sustainability itself, the whole debate started from the environmental context. And the same is here in the competition debate. The whole thing starts with environment. But then in the sustainability debate, it became clear, well, you cannot just like say, well, we're not going to cut down forests because people are dependent on those forests to get their food, to get their firewood. So there is a development aspect to it. There's an economic aspect to it, and that should be not seen as something that is not part of it. So it's slowly kind of extended. And I think that's what we are also seeing if we are looking into this debate in antitrust. We start and see the most examples in the environmental context, but slowly we're getting to see other areas. And there's a little less examples from that area, but I think we are getting there. And that brings me to my question to Julian. I was thinking about the example that you just said, and I think it's a very good point with the carbon leakage that you said, is that the emissions that would be happening in Europe are now then happening in India, and we're not having any kind of effect. And I think that's a very serious point. And I think the Dutch Competition Authority has, based on these conditions back in the days when they had a case about coal-powered plants, rejected an agreement to shut them down, because they said, well, we are having this agreement, but you're still getting the emission rights under the European Emission Trading Scheme, and you can just sell them on to the market. You're shutting down the coal powers here, but someone else is going to emit that. So I think it's a very important point. But I was just thinking about the banks. It's like, if the coal-powered plants are not being built in Europe, are they then necessarily built in India? And I wasn't sure, because I was thinking that in that sense, electricity might not necessarily as manufacturing. I think in manufacturing, it's different, but in electricity terms, would be slightly different. I think it's a more localized question. That was just a couple of thoughts.
Okay, thank you, Julian. Yeah, sure.
Just, it's a very good argument to broaden out the thing when I've been quite specific about competition law. You say that it's the biggest market failure in the world in talking about environmental issues. But what we're specifically addressing here is the role of antitrust in this whole schema of things. It's not the fact that the world is collapsing or we're all going to die. It is very specific about the role that competition policy can play. I don't know about this insurance example, and I don't know whether, when you say the advice, was it the lawyers who were giving the advice or the competition authority saying it was blocked? Because one of the things the commission said was that lawyers are being too timid. We're not enforcing antitrust against these cooperative agreements that lead to sustainability.
Can I quickly interrupt?
Yeah.
Because there's a case, we have the Americans here. I think there's a case in the United States brought exactly under antitrust against a similar situation. I think from the Attorney General in Arizona. Who was
I saw the email, Mark. That's not the point. There's probably a case in Papua New Guinea that says something quite different. But the issue here, I'm talking about the European Commission and European law. I know we had a lot of stuff about it. US antitrust. I'm just saying that we really have to be quite clear in what the parameters of what we're talking about. It's very good to suddenly explode it out and give examples and then say, oh, this is it. But what the commission said in terms of its reaction to this debate was that lawyers were being a bit too risk averse in advising their clients, no, this is going to be against competition law. And instead of going to the commission and finding out what the real situation on the enforcement priorities are. And that's why it's a good thing, I think, that the various competition authorities are clarifying, what the agreements that will pass through or not. This is somewhat an issue of legal certainty or uncertainty as resulted in everyone being saying, oh no, this is cooperation between competitors. That's it. On trade-offs, I was quite struck by the debate this morning where lawyers are talking about, this technocrats can make these trade-offs and they can decide almost unilaterally what they're going to do. I think there should be a bit more respect for the rule of law. We've got to have a situation where there are rules that lead to certainty, that lead to deterrence and guide actions of individuals. If it's felt all the time that the regulator is going to trade off various social and environmental goals against competition, then we just change the name of the regulator of happiness and goodness in the world, rather than it being an antitrust authority.
Okay, I don't know, Julian, if you want to go ahead with continue with your, shall I continue with your question, or I go first to Maurits, because we are more,
Let's move on.
I think the question, I think it fits better in the current discussion. Okay, so there is the argument that businesses are deterred too much by current analytical framework employed by competition authorities. However, there is room also to say that, well, they are not deterred so much to agree on greenwashing agreements like the very recent AdBlue cartel. So, Maurits, how to distinguish between agreements with negative effect on competition and sustainability from agreements with positive effect on sustainability? And I believe you have something you would like to show here.
Little decision tree that
I don't know.
well, while they are looking for it,
Yeah.
I would like to point at 2 points of agreement between Julian and me and Cento and me. The agreement between Julian and me is that much of the solution to climate change is going to come from innovation. And how do we get innovation? What drives innovation? And competition drives innovation, I agree. In particular, where consumers are willing to pay. If they're not willing to pay, you have that, there is this question. But so I do agree, fourth generation nuclear technology is a brilliant example. Molten salt power generation by small startups like Copenhagen Atomics or US companies like Flibe and so on. This is really brilliant stuff. And this could be a sea change in the energy transition. And I think a few things have to happen. Deregulation, it's not a form of deregulation, but it is a form of targeted regulation that is fit for that technology, which is entirely safe, doesn't explode, doesn't melt down, and so forth. So regulation should be adjusted to that environment. So that's, I think, a point of agreement between us. If you prohibit unabated coal power plants, I think that could be part of the driver of innovation, because right now these coal power plants and oil and gas gets enormous amount of subsidies, right? $700 billion last year only for the oil and gas industry, right? It's so don't come to me with raising prices for oil and gas. I mean, it's they get an incredible amount of state subsidy. And so, and that distorts competition because in the absence of that subsidy and in the presence of cooperation, there could be a driver towards better, cleaner technologies. And that's, we're going to...
When you say 700 billion, is that because you're including the externalities from...
No. This is just
the direct
state
subsidies.
Julian, it's direct state subsidies. I can follow up with you later if you wish, but it's direct.
Not in Europe and the US.
No, this is worldwide.
Right, okay.
This is worldwide. Yeah.
So something like 100 billion in the EU.
Yeah.
Yeah.
And it's incredible. And it consists of direct payments. It also means, for instance, tax exemptions, no VAT on fuel for airplanes, for instance, whereas everybody else in your car, you pay VAT. So things like that. So we should keep that in mind. That we need innovation. So stopping that kind of direct subsidies is one thing. The tree is up. So let's quickly go through it. How to because I agree that there are situations like the AdBlue case where companies tried to rig the market under the cloak of sustainability, and that should not be allowed. Right, so let's assume that there is an agreement that restricts competition. So that's step number one there. And step number two, the question is, okay, is the objective justification, is the purpose of this agreement a climate change abatement? We can talk later about other sustainability goals. I prefer to focus on what's really systemically threatening our existence. So that's why I talk about climate change. So the first question you ask yourself, is there a market? No, please leave it. Can we get back to the previous one? The second one is for if you really want to get complicated. Oh, can we go back to the little decision tree, please? I saw the time. All right, I can summarize it in one sentence.
No, the previous one.
Previous one, please. Thank you. Keep it. First question you ask yourself, is there a market failure? Are consumers sufficiently willing to pay? Or is there adequate regulation that drives innovation, for instance? If so, the parties should compete on being clean and green, and competition should drive the solution. On the other hand, and then we get to the lower part of the first branch, is if there is a market failure, if consumers are not willing to pay sufficiently for sustainability and there's no adequate regulation, then coordination is required. And we assume, and I see, like Julian Nowag has indicated, that there is a regulatory failure. Even if in the EU there is now more and more regulation and emissions trading rights and so forth, it's not worldwide. So there is a regulatory failure and a market failure. So then the question becomes, and unfortunately some of the tree is not visible, but I'm sure it can be circulated, and it's also in an article I wrote. What are the parties really trying to pursue? Are they trying to pursue short-term profits, like in the AdBlue case? We can talk about the AdBlue case if you wish, but probably don't have enough time. But the parties were pursuing short-term profits at the expense of sustainability, and they were using sustainability as a cloak. Or are the parties pursuing long-term spillover benefits? So the long-term spillover benefits is a situation, for instance, where you seek, you realize that as a company, if you don't do something, the economy may not exist, and certainly not in the same form. Our society may not exist in the same form if no action is taken, and part of that can be resolved by agreements that create positive externalities or that create spillover benefits. And an example of this is this agreement between these insurance companies, because our agreement creates, it's not intended to raise profits, right? Because that would be a cartel. We're not suggesting that cigarette manufacturers can collude and raise prices because that increases human health, because fewer people smoke. That's not the argument. The argument is that if the companies really pursue genuinely sustainability goals, whereby society and companies themselves benefit not in terms of higher short-term profits, but long-term survival, long-term lower costs, and so forth, then an exemption might be possible. And we can talk later about fair share to consumers and so forth. But this is my little decision tree that can be used as a framework for analysis.
Thank you, Maurits. Do you want to add something to Maurits Cento?
Yes, one sort of factual, almost, well, theoretical question is, you've posited a situation where, sorry, they've cut off your, that the consumers are not prepared to pay in the short term and the medium term. But these firms get together and say that for our survival, whatever that means, we should have a sustainability agreement. That sustainability agreement is just going to cost them money, and there's no immediate return to that money. What's the mechanism that drives them to pursue these sustainability goals when there's no return to it? I don't understand what the sort of theoretical underpinnings of that would be.
Yeah, so economics, as you know better than I do, because I'm not an economist, is about incentives, right?
Yeah.
What are the incentives of these companies? Why would they, and you can look at the incentives are expressed in internal documents, in the nature of the agreement, whether they do these agreements secretly, whether they involve other stakeholders in deciding whether this agreement is appropriate. So there are external factors that you can use in order to find out what the incentives are and whether the agreement is actually a reflection of these incentives. And cloaked agreements like AdBlue, secret, not involving stakeholder cooperation, their objective was to raise short-term profits. So that's a cartel. On the other hand, the GFANZ agreement, or the Race to Zero agreements, the objective there clearly was not short-term profits, because they were actually foregoing business, right? And the objective there was to create these positive spillover effects, whereby the private interest of the insurance companies in the long run coincides with the public interest in abating climate change. And those are the kind of agreements that should be allowed. Yeah. And that agreement was clearly discouraged by antitrust law. And that's the other point of agreement between you and me. The initial advice that the lawyers gave, in my view, was too conservative. On the other hand, from an EU perspective, from a US perspective, from a Chinese perspective, from an Indonesian or a Brazilian perspective, we have a complete fragmentation of antitrust enforcement such that the strictest antitrust enforcer dictates the policy for everybody else, just like the slowest ship in the convoy determines the speed of the convoy. And we need to go fast and not slow.
Okay, I don't want to prolong this aspect of the debate, but if the incentive on the firm to engage in a sustainability agreement is a threat of future regulation.
No, that's
No, it's not what you're saying. Then I don't understand
the threat of future antitrust enforcement,
future antitrust enforcement.
which is different from future regulation.
No, I meant, let's forget about the market power issue for a moment. There's this subset of agreements that you would let through because the firms have, the term used was for their survival. They agree on a set of sustainability goals. Those sustainability goals are only going to cost them money. So what I was really trying to tease out was, why would they agree? If it's only going to cost them money, consumers are not going to pay for it. That was the assumption of the analysis. And why would they agree to these sustainability goals?
So there are, let's say, three reasons. First of all, this agreement was predicated on the milestones of the International Energy Agency. And there is another slide, but not here, the IAE has set about 30 milestones, which we need to achieve in order to get to net zero. These are the first ones. This is the first milestone. So they didn't invent it. They took it based on an enormously deep substantive study of what is needed to get to net zero.
But
The second thing is
can I quickly interrupt? Because I'm not sure, like, I have a feeling you are talking past each other. So he basically asks you what is their profit-making motive to engage in that agreement?
making motive is the positive externality of this agreement for you and for me.
Yeah, but that's not going to make the money.
Well, it's actually, well, yes, it is going to make the money because it's going to reduce the physical risk to the assets you insure and the assets that I insure. So it's going to make the money, and we have a long-term objective of basically our society as it stands now to survive.
Well,
and
I might disagree with that, but the point
There's also a basic misunderstanding of the insurance market. I mean,
I wasn't talking about insurance. I was talking about the general proposition.
I'm not so sure about that, but
I was talking about the general proposition that there is a subset of agreements where they will cooperate together to enact costly sustainability investments on the assumption that consumers are not prepared to pay for it. So there's no profit in it. And I think the only response you've given me so far is that it's regulation or quasi-regulation that's encouraging them to go for net zero in some long-term extinction threat of humanity. I'm just putting it in colorful language.
Yeah, I'm clearly not explaining myself clearly. So it's not a threat of regulation. It is the threat of antitrust enforcement against an agreement which creates benefits for the parties and for society. And we can talk later about consumer.
I still think you're talking past each other, because that wasn't the question. The question that Cento was asking was, how are the companies going to make money out of this? If it's not because there's some threat of actual regulation as opposed to antitrust enforcement, then what is it? And then that's my point about your misunderstanding of the insurance market. The insurance market takes in premia and spends those premia, puts those in premia investment, and then if there's an event, they pay out. Now, climate change is a long-term threat, so the idea that you're going to offset a reduction in short-term premia by some sort of long-term reduction in threat from climate change, I just don't buy that argument.
It's a long-term versus a short-term assessment. If we are dictated by the profits of the next quarter only, right, we are going to continue to exploit the public goods, which water, air, the climate, and that will impose costs on in the long term, right?
There's
I will be
a
paid by
category.
the time.
There's a category of insurance that for which this applies, and it's cat bonds, right? So it's catastrophic insurance bonds that pay out. They're long term, so you bring in money, you put it into investments, and then at some point, if there's a really catastrophic event, it pays out. But those are they're very it's a very minority market. It's not insurance of coal companies.
Yeah, but these companies are not just focused on short-term profits. They look at the longer term. They also are aware of extreme weather events, which increase in frequency and intensity as climate change happens. And that is what drives these companies.
Okay, yes, to bring another perspective on the table on the relation between sustainability and antitrust, Julian Nowag, you see a way to analyze the overlapping relation they have. So
Yes.
can you
So I have this
explain
kind
to
of
us?
a simple Venn diagram. So I think it's not, the question is not either or. The question is,
There is another
it's a two
slide
slide, I think. You
after
try
this
to-
one.
No, before,
Or
Yes.
there was
two before. One, no, next.
no, after
After that one?
Maurits' slide was.
I thought,
It's a Venn diagram.
it's a Venn diagram, but I'm just. This one,
That's it?
exactly. So, so this is the kind of thing where I think we sometimes get lost in the detail, and we are talking too much about either or, and I think it was there. There it is. Perfect. So I think a lot of things can be done, and that's where we should talk about. And I think you already, Cento, rightly highlighted the risk averseness of lawyers, advisors before, and I think that might now change with the fact that we are talking about these matters. But I think that taking it in these kind of extremes doesn't really help. I think you want to identify the overlap and talk about the overlap, and then see where do we actually disagree. And I know that some areas where we disagree are questions that Maurits just raised, and those are the kind of debates. But there's, I think, a lot of things that are perfectly fine. So I'll give you an example. You can think about agreements. Let's talk again about agreements that are either in Europe without outside of the scope, or you would need to have an effects assessment. Those agreements are standard setting agreements, where we know standard setting agreements are usually rather positive. And in the EU, you have now a proposal for having standard setting agreements for sustainability standards that fulfill certain criteria. And I think we can talk about stakeholders, because I would also be rather skeptical of private companies' motives. I still think there's a value in asking the question, what is their benefit from them? So stakeholders might be something, if they're involved in that setting, that might be something that counterbalances that. But anyhow, so coming back to standard setting, in the US, we have a rule of reason approach. In the EU, we have now a proposal to have a kind of what the Commission calls a soft safe harbor. If you're complying with those conditions, then you're not going to be having a problem. And I think those are the kind of things that we should talk more about. And that's the kind of things where maybe we don't have a gap, but I think those deserve to be highlighted. And that's, we can discuss about abolishing the consumer welfare standard and replacing it with a sustainability standard. I don't think that makes a lot of sense, but I think trying to identify the overlap, sustainable innovation being one of them, is something that we can do and we should aim to do.
So I agree to some extent with the other Julian. So let's take us back to the origin of the term sustainability, which, as I understand it, goes back to fisheries economics from the 1950s. Tony Scott and Scott Gordon.
Goes back to actually the Catholic Church.
So the term, right? So, but the term sustainability was used, or sustainable yields was used in both fisheries biology and fisheries economics to talk about the amount of fish that you could catch without depleting the stock. So you have the maximum sustaining yields. That's the maximum that you can take out of the water without reducing the amount of fish that exist going forward. And so that then became somewhat the basis for this idea that you want to enable people to meet their own needs today while not inhibiting people from meeting their needs in the future. That's the kind of the World Conference on Environment and Development's definition of the Brundtland Report's definition of sustainable development. And it's motherhood and apple pie. It's fine, and no problem with it at all. And let's go back again to fisheries. It makes a lot of sense in the context of fisheries to have one entity control the use of the stock. Why? Because if you have competition over the capture of an open access resource, so this was Jeff's point about common pool resources, if people are competing to take out a biological resource which otherwise would be self-sustaining, then they will tend to invest heavily in capturing as much as they can in the shortest period of time so that they get more than the others who are also competing to capture that stock. It was somewhat inappropriately called the tragedy of the commons in a famous article in the 1960s, but it's really the tragedy of open access in the face of competing users. Fisheries economists realized very early on that the solution to this is monopoly. You have a single owner of the resource, and that single owner has a strong incentive to make sure that that resource grows in the future at a rate that increases the value of the resource to the person. So to the extent that that sustainability is about those kinds of problems, the problems of common pool resources, then allowing collaboration, allowing agreements amongst otherwise competing users makes perfect sense. But it also makes sense in a consumer welfare sense, right? Because the consumers are going to be better off because there will still be fish in the future. So you have, instead of your Venn diagram with two things, it's aligned. To the extent that you're talking about these common pool resources, the alignment is perfect. And I think that the alignment may well be perfect in other contexts. So, for example, patent pools and other ways of collaborating on information sharing. I have trouble finding examples where there is not alignment between the consumer welfare standard and sustainability that actually merit exceptions. I'd be very interested to find out if any of you really can identify some genuine instances of that, where consumers are really going to be better off if you do something that's unsustainable.
I agree with every word you said.
Julian, I'm shocked.
Yeah, but Maurits, in addition, I agree. It's in my opinion, it is very clear to see why conservation cartels makes a lot of sense, right? We have not mentioned the first mover disadvantage. That is actually, I would say, the main deterrent for companies to innovate and compete. And I don't know how you see my proposition in the light of how here, for instance, in Europe, with the horizontal guidelines and other initiatives from other national competition authorities are taking this matter.
So the first mover disadvantage, we talked about collective action problems and market failure, and the first mover disadvantage is an emanation of that. Let's take the fishing example that Julian Morris was talking about. The first mover would be the individual fishing company that decides, my market share is 1%. I'm going to fish 1% of the sustainable amount, and no more. And by my example, I'm going to try to convince the others to do the same. And then the others are just going to fish more. That would be the first mover disadvantage. So I think that would be an example. So we have actually already discussed it when we talked about collective action problems and market failures. And I think this is what happens also potentially with the climate. Say, for instance, a company that decides I'm going to switch my tropical wood to sustainable tropical wood, which is more expensive than the stuff that's just cut wild without regulation, but which is grown over a long period in plantations in areas where you don't have deforestation. That's going to be more expensive wood. If they move, if they're the first one to move, their product will be more expensive. Others will eat their market share, and that's the first mover disadvantage.
Okay. So before going to the questions or comments from the audience, just to close, I would like you, Julian, Maurits, I'm turning the initial question. We have started talking about asking about whether there was a sustainability gap in antitrust. Now, I would say, is there an antitrust gap in sustainability, or how antitrust finally can really, or competition policy, procure sustainability goals?
And I feel like my last comment sort of addressed that in some respects. I think that this idea that there's a sustainability gap is premised on probably a misunderstanding of both antitrust and sustainability. So it misunderstands that when action is taken that results in more sustainable use of resources, that also enhances consumer welfare. So in that sense, there isn't an inconsistency in terms of the current dominant framework of competition policy vis-a-vis sustainability. So I don't think there's a gap necessarily. To address the first mover disadvantage problem, I mean, I think the more common kind of way of looking at that is the problems arising from investments in innovation and declining marginal costs, right? So where it costs $1 billion to develop the first pill and $100 to copy it, then you have a problem in terms of incentivizing the innovation that results in the first pill. I mean, and there's two elements to that. One is there is going to be a significant cost in that development, the development of that pill or that new way of producing electricity. And so that's inherent. And then there's the added costs that come from regulation. So one question I have is whether it's going to be difficult for antitrust to do anything very much about the first problem, just the costs, the normal costs involved in doing research and development. But can antitrust be more aggressively involved in combating unnecessary regulatory costs? I don't know the answer. I'm not an antitrust lawyer or even actually an antitrust economist. My expertise is mainly in the economics of the environment and sustainable development. So I guess that's why I was invited to this panel. But I'm intrigued by the idea that some of these barriers to innovation, which, as we've discussed, are so important to the future of humanity, might be somewhat brought down, but through using. So it's competition between state agencies, I suppose, at some level, because is one state agency empowered in some respects to combat the overreach of other state agencies? And I don't know the answer to that question, whether it's even a good idea, but I'm just posing it.
I would like to just briefly, because I would like to let
Very
people-
briefly, I mean, I'm not sure that I understand the first mover disadvantage argument. Obviously, if innovation has massive externalities and it's just going to burn the profits of the firm introducing that investment, and they will be reluctant to do it. But the scenario that's being painted is that these firms are engaging in sustainability agreements which inherently don't have any profit return to them. So there's no first mover disadvantages. If there is a return to them, whether it's a market return or the threat of regulation or Pigovian tax, which is, then there may be a reluctance to do it, but they will do it because it's in their financial interest to do it and in their reputational interest to do it. So I don't understand why in the scenario painted in the decision tree, that first mover disadvantages is of any relevance to that calculation. And that's just my comment on. And also just with respect to that, where I do agree that cooperation and market power are useful is in these conservation cartels. And you don't need monopoly, you need the assignment of rights, as you well know.
And finally, Julian, just.
Yes, so I was just like thinking, we had now a debate, and I was just like trying to think, the debate was in a certain way very nice and we found some common ground. But it again focused on one particular aspect. And I think before we open the floor, and some people that have read a bit what I write might be bored now that I say that again, but we have basically talked about how we might not enforce competition law if there are some benefits in terms of sustainability. There's also the other part where you say maybe a bit more pro-enforcement side, where you say, well, we're going to attack cartels. You have an agreement in France that has been sanctioned not to advertise on the environmental performance of hardwood floor. You have the AdBlue case, which was also about reducing the innovation that could lead to increased or better emissions filtering for vehicles. So I think there's the one side which we always end up in these circles to debate, which is kind of how can we make it easier for companies? But there is also the other side, and I just wanted to highlight that before we
Okay,
open the floor.
thank you, Julian. Any comments or questions?
Hello, Thibault Larger. I have a fundamental issue with sustainability agreement that we've not touched upon here. And I'm going to be extremely simplistic. Who wins, who loses in the case of competition, in the case of monopoly. And in both cases, we will see that consumers lose and firms get a sweet deal. Let's take the fishery example or whichever. Competition. The fishermen can sell as much fish they want. They destroy the planet. We eat fish, but we live in a dirty planet. Too bad for us. The fishermen are happy. We are unhappy. Let's do sustainability agreement as the solution for everything. Fine. Monopoly, so less fishes, fine, but consumer will pay a lot. And the companies, the fishermen, will be happy. They will have profits and they can blah, 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 sustainable. So in both cases, the equation is the same. Consumer lose and company gets a sweet deal. So I'm going to ask you your input on that. In the competition case, the usual commission will tell you that there's an investment issue, an investment gap. We need to give state aid so companies can. So the responsibility is that there's a market failure. This is not the fault of the company. That's the market that is not working properly. So we will allow them to do some stuff, but the responsibility is still partly on the side of the of the companies. So how would you solve this? So first, do you agree that the winner-loser case is the one I described? And second, how would you do so this is not always the consumer who are losing, and we can share a bit the burden between companies and consumer. Let's think about another case if that's better. The German car companies who cheated on the emission standard. That's a very good example also for that type of win-lose scenario.
Just a quick response on fishing. I mean, I don't think I've met a happy commercial fisherman. They're subject to regulation.
Okay.
Give me a go. Yeah. Yeah, I'll answer your question. You can give me another one later on, but if the fishermen have property rights assigned to them, or there's a monopoly or a cartel, they will conserve the fish. The prices to consumers will go up, and that's a good thing because it's the conservation of fish. The fishermen will make profits because the problem with overfishing is there are too many fishermen and they're eating each other's profits as much as the fish. So you restrict the number of fishermen, and that's why consumer benefit, environmental control, sustainability all match into one double circle.
In the long term, there are actually real world cases of this, many actually around the world, but two that most obviously springs to mind. One is Iceland and the other is New Zealand, both of which have established property rights in fisheries. So they start by saying, okay, well, we're going to have a single entity that controls total catch, but then they divide up the rights to that catch among quota owners who can then trade. That's the basic setup in both countries. And actually, there is a monopoly on some of the fisheries by a company in New Zealand. So there is literally a monopoly, but that company just has the rights to determine what the total allowable catch is, and then the catch is shared by the fishermen. The fishermen have all been enormously happy. They were resisting it beforehand, but afterwards they were very happy because the value of their quota, which they were initially allocated on a per boat basis, went up because the total allowable catch was lower than before, so the value of their quota rose. Many of them sold out their quota to more efficient boats. So you had improvements. You did get innovation improvements in fishing, but you kept on with a lower catch. The consumers benefited because they still had fish, right? So yes, the price initially rose because the quantity was lower, but going forward, they found that the fish stocks recovered and they were able to catch more, and the price went down again in both places, in both Iceland and New Zealand. And now Iceland produces enormous amounts of fish relative to its previous position with regard to the Dogger Bank and Grand Banks, which have been massively depleted because of failed government regulation over fisheries, first in the US and then in the EU.
So that's I'm returning a bit in round, and then I'll stop. But what you're saying is exactly exemplifying what I'm saying. You say, oh, fish stocks were depleting because of failed regulation. It's not the fault of the companies. The market is not working properly. Too many fishermen, greedy, they all want blah, blah, blah. So in the end, it's still, and then you describe the after and you say, oh, they were very happy, they had quotas, monopoly pricing, they could exchange that, they could sell that, that's great. So in both cases, what I get, I'm very simplistic, but the fishermen are getting the sweet deals toward consumers. So the first one, we are going away where soon we won't have fish anymore. In the end, we have fish, but of course we pay high price. That's fine. But in both cases, the fishermen have an implicit insurance that make them okay in the end. So maybe there were a little bit more fishermen at first, and the competition was a bit fiercer.
No, I'm sorry. In the situation of competitive fisheries over an open access resource, the fishermen, unless they're subsidized as they are in the EU, suffer because they're investing more and more in order to catch fewer and fewer fish. Whereas in the case where
they are subsidized everywhere. That's all. Like most of the trade negotiation at the fish chapter.
Can I quickly come back to your point about the consumers lose?
Briefly, please.
Yes, very quickly. So I think the consumers lose in your example. Yes, they pay a higher price for fishes, and then you have to basically do a trade-off with the fact that tomorrow they also have fishes. So that's a trade-off. But we are now at fishes, right? So fishes. You can either have cheap fish today, or more expensive fish today and tomorrow. So that's a trade-off that you have. And there's actually a case from the US where they have given a business review letter regarding exactly that, where fishermen had set up a cartel to allocate these kind of quotas.
Yeah.
Yes, but that's a regulation. It's not done by companies.
So I think we are out of time. I don't know if yeah, a last question from, okay, Marcos. Please, no fish. Yes.
Okay. Well, it was actually going to be a fish case that I had some time ago, but then I'll drop that. But essentially, whether it's fish or not, the only solution in that case was to set up a cartel and boycott non-compliant fishermen, that were sneaking out of the cartel. So sometimes, you really need strong discipline, but that has already been indicated by the panel. Now, my question was specifically in this diagram, and particularly in step 4 in the number, if I remember correctly, where essentially it was suggested that if the companies were making money, with short-term profits or whatever, it wasn't clear whether long-term profits would be on the basket or not. But essentially, the message was, if the companies are making money, then they are not caring for consumers, so that should not be allowed. And I was wondering whether that was a suggestion to try to square the AdBlue weird case of the European Commission, or whether we really think that exceptions to the competition prohibition should be conditioned on the companies losing money. Because if that's what we're saying, that's not going to happen. Thank you.
So those indicators in step 4 are indicators. They may create presumptions, or they are relevant criteria. They are not each and every one cumulative conditions for the finding that the companies are engaging in a cartel. Nor is the absence guaranteed to then lead to an exemption. There are other conditions for an exemption, like necessity and proportionality and so forth. So it's just an indicator. If companies sit in a back room, a smoking back room, and raise prices, and then try to argue that raising prices is good for consumers because it reduces demand and therefore reduces output, and that's good for sustainability, that won't fly.
Okay, final comment.
One final concern about these collusive agreements between otherwise competing firms relates to the potential for them to inhibit disruptive competitors, which I think, if that was the case, I think I would be very worried. And it was the case in a famous example in the US in the 1950s and 1960s, where the car manufacturers colluded to slow down the development of pollution control devices and explicitly excluded outsiders from participating in their agreement. So I think add that in as a very important element in making an assessment of these things.
Thank you very much. Yes, that case really shows the very relative limits of cooperation here. And just to close, I would say that ideally competition should promote innovation, and innovation should be the best way to meet sustainability objectives. Thank you very much to my panelists. A big applause to them.